the courtroom goes silent. Files open, eyes lock onto one man, Advocate Zithulele, and today he came armed with research that shook the state's case to the core. Representing accused number 4, Nxumalo has been laser-focused on one of the biggest pressure points of this trial. Confessions. Were they real? Were they coerced? Were they even admissible?
My lord, I've also prepared heads of arguments.
Okay.
My lord, I've also made a copy of the judgment from the Western Cape High Court. It's State versus Lansing and others. The judgment was delivered on the 11th of August, 2025.
Okay.
I made a copy for the... Under introduction, the gravamen, my lord, of this application arises from the fact that during cross-examination by the state to accused number 1, the state intended to use a statement, Exhibit JJ, made by accused number 2 to cross-examine accused number 1 in order to establish the evidence aluende in the commission of the offense. Evidence aluende is evidence out of the statement that was made by accused number 2, Mr. Ndanzi, before court. I must submit, my lord, that the defense vehemently object to this, as it violates the accused's rights in terms of Section 35, subsection 3 of the Constitution of the Republic of South Africa. The state alleges that the statement made by accused number 2 is an executive statement, as it was made in the furtherance of a common purpose or conspiracy. It was along that basis, my lord, that the trial within the trial was conducted for the admissibility of a statement made by accused number 2 before the magistrate, Ms. Cronje, on the 24th of June 2020 at First Loras Magistrate's Court. The trial within the trial was conducted in order to determine the admissibility of that statement, as accused number 2 contested the admissibility of the statement on the basis that it was not made freely and voluntarily, but under threat of assault. The court nevertheless ruled that the statement was admissible and it can consequently be used to test the veracity of the contents. My lord, the defense responded to my heads of arguments, which were filed on the 15th of August 2025.
Yeah.
At paragraph 21 of the state's heads of arguments, in an application for a discharge of accused number 4 in terms of Section 174 of the Criminal Procedure Act 51 of 1977 as amended, the state submitted that the importance of not distinguishing between confession and admissions when used against another person means that the executive statements are admissible evidence against the co-accused if they are made in the furtherance of a common purpose or conspiracy. They made reference to a book by Hoffman and Zreffert, 4th edition at page 19, and contend that the book explained what is executive statements made in the furtherance of a common purpose or conspiracy, and they are admissible against the co-accused. In order to be admissible, the statement needs to form part of the acts done in the commission of a crime. I also did the research, my lord, on this subject. And I came to the following with regards to executive statements. The executive statement of A, who acts together with B and C in the furtherance of a criminal enterprise, are, if they are performed in the furtherance of a common purpose, viewed as being not less than a statement of B and C. They may therefore be adduced against B and C if they have been made by those parties themselves. The statement by A is admissible against B because the statement is by law a statement that is attributable to B as much as it is to A. The state, my lord, therefore submitted that the two confession statements are attributable to accused 4 and the other accused, as much they are attributable to accused 2, and it can therefore be used to cross-examine accused 1 about the contents of Exhibit JJ. I submit, my lord, with due respect, that this is an attempt by the state to force open the door for the admission of such statements as executive statements against the co-accused, and this could undermine the integrity of the courts and our jurisprudence, and it should be discouraged at all costs.
Zithulele dropped his first bombshell. A confession is only evidence against the person who made it, not against the co-accused. He backs this with South African statutory law and case law like he's reading from the Constitution itself. The implication? Even if a confession exists, it cannot magically incriminate the others. Explosion in the courtroom. But he goes deeper. He attacks the voluntariness of every alleged confession. The law demands strict compliance. It must be made freely, voluntarily, in sound and sober senses, and without undue influence. So Nxumalo asks, were the rights explained? Was there time to think? Was there access to a lawyer? Did police pressure these men? The answers are uncomfortable. Zithulele then zooms in on procedure. Who took these confessions? Were they properly confirmed before a magistrate? Was every step of the Criminal Procedure Act actually followed? Because if one step is skipped, one warning forgotten, one right denied, the whole confession becomes invalid. You can feel the state sweating. Even the timing of these confessions is suspicious. So fast. So neat. Too neat. Zithulele suggests pressure. And where pressure exists, voluntariness dies. And what about the recordings? Yes, one confession was captured by a magistrate. But Zithulele questions how it was handled. When was it used? Was it properly recorded? Where is the chain of custody? Loose ends everywhere. He challenges senior officers, cross-examines justices of the peace, and exposes inconsistencies in how these statements were collected. Piece by piece, the state's neat puzzle begins to crumble. The court ruled that the confessions were admissible. But here's the twist. Zithulele's submissions still matter, because if these confessions were tainted, even slightly, their weight at trial could collapse. And that's the defense strategy. Let's listen to these.
The common law exceptions. At common law, there is an exception, my lord, to the exclusion of extracurricular statements of co-accused if the statement constitutes an executive statement by an accused. It may be admissible against a co-accused if it was made in the furtherance of a common purpose. Executive statements, more commonly referred to as statements made in the execution or furtherance of a common purpose or conspiracy, is an extracurricular statement, out of court statement made by one conspirator that is admissible against the other conspiracy. The crucial element, my lord, is that the statement must have been made during and in the furtherance of a common purpose or a criminal enterprise, and not after the fact, like many confessions. My lord, what this entails, I'm going along the lines of my colleague's submission, Mr. Ramsepel. What the aforesaid statement means is that the accused must be arrested for having committed the offense, interviewed in respect of that offense, and a statement obtained from him, like in many confessions. The general rule is that a statement by one person is inadmissible against another in terms of the provision of Section 219 of the Act. I'll follow suit, my Lord, and state that I don't want to validate that by mentioning a confession and validating the accused, that is accused number 2 statement, Mr. Ndans. I've dealt with executive statements. A confession on the other hand, my Lord, is an unequivocal acknowledgement of guilt, equivalent to a plea of guilty in a court of law. In this regard, see R. versus Baker, 1929 AD, at page 167. The relevant definition of a confession is found at page 171. Such statements are admissible against their maker only. As stated at paragraph 3, my Lord, when one was dealing with or the discussion of executive statements, they are made as part of an ongoing plan or execution of a crime. For instance, if one says, I've hidden the money at X location, that is an executive statement which is made in the furtherance of a common purpose or a conspiracy. This statement, which can be used as evidence against other members of a conspiracy because it is considered as an act of furtherance of a common purpose or conspiracy. Therefore, a post-crime confession of guilt by one person cannot be used as an executive statement to prove the guilt of the co-accused. The law treats executive statements and confession statements differently with distinct rules of admissibility and applications. Executive statements in the context of common purpose. The term is used to describe statements made by one party during the planning or execution of a crime that may be admissible as evidence against co-conspirators. These elements are part of the execution of a joint unlawful activity, not just a narrative of past events or an admission of guilt made after the fact. My Lord, I also found the useful case in this respect or discussion, the case of R versus Blake and Tai. It's an 1844, volume 6, QB 126. It's a UK decision. It provides, my Lord, an example of the distinction between executive and narrative statements. Narrative statements, my Lord, being confessions. And I've detailed the definition of a confession, which is an acknowledgement of guilty by the accused, equivalent to a plea of guilty in a court of law. For instance, in that case, a scenario was given in order to define the activities by the accused as executive statements and confessions. It reads as follows. The accused were charged with a conspiracy to pass goods at customs without paying duty. Tai, who was the co-accused, had made entries incriminating both himself and Blake in the 2 books. The entry in one of the books was part of the fraud, whereas the entry in the other book was solely the record of his own private purpose. It was held that the first entry was admissible against Blake as something done in the furtherance of a common purpose, as an executive statement. However, the second entry merely constituted evidence against her because it did not advance the common purpose, which is a narrative statement or a confession, which is not admissible against the other. In this respect, the learned author Swikat P.J. and van der Merwe, S.E., in the Principles of Evidence, 4th edition, at page 345, deals with the similar issues. My Lord, in State versus Lansing and others, in bracket, open bracket, CC08/28 in close bracket, 2025, ZAWCHC. It's a Western Cape High Court decision at page 341, delivered on the 11th of August, 2025. I must submit, my Lord, that the facts of that case, the Western Cape decision, are distinguishable from this case, but the principles in respect of the admissibility rules and the discussion on executive statements and confession statements are similar. The state, in that case, the Western Cape decision, submitted that in all circumstances, that so the contention proceeded, the evidence alluende, indicates that the statement of the three terrible Josta gang members acting in the common purpose. Counsel implored the court to admit the warning statement as evidence in the trial against accused 3 and accused number 14. The central question was considered, or to be considered, was whether a warning statement made by Mr. Sabtu, who was charged together with accused number 3 and 14 in the lower court, can be used as evidence against them in a subsequent trial in the High Court. In the instance where the maker of the warning statement is charged together with accused 3 and 4, and in this court, in respect of the same offense. I've indicated, my Lord, that the facts in the Lenting case are distinguishable from the facts of this case, in the sense that in the Lenting case, the court was invited to determine if a warning statement made by the deceased accused amounted to an executive statement made in the furtherance of a common purpose or conspiracy, implicating accused 3 and 14. As a point of departure, it is necessary to emphasize that the fact that at common law, an extra cura statement of an accused was inadmissible against the co-accused. It is only in exceptional situations that an extra cura statement may be admitted not only as evidence against its maker, but as evidence against co-accused implicated thereby. The first is where, my Lord, the co-accused, by his own words, asserts the truth of the statement to make all or part of the statement his own. The second exception applies to extra cura statements made by a co-accused in execution or furtherance of a common purpose or conspiracy. Such statements are admissible in evidence against any other person involved in the collusion. I now deal, my Lord, with the arrest of accused number 2, Mr. Ndanzi, before court. On the 16th of June, 2020, the investigating team led by Brigadier Kininda, who is the head of the National Court cases, arrested Bongani Ndanzi, accused number 2. On the 19th of June, 2020, accused 2 made a confession statement before a commissioned officer, Colonel Rapaldi. On the 24th of June, 2020, accused number 2 was made a second confession statement before a magistrate, Ms. Konyen, at Fostora's Magistrate's Court. It was on the basis of those confession statements that accused number 4 was arrested. From the exhibit, my Lord, that is exhibit JJ. The salient features, my Lord, of the statement are that accused 2 submits that, the salient features, my Lord, are that accused 2 statement, the state submits that they can be used to cross-examine accused 1 about the involvement of accused 4 in the commission of the offense are the following. That accused 2 used to work in Carltonville in 2014. He received a call from Sfison Dodi, accused number 5. He got his number from Mozi, accused number 1. They asked him to come to Basotho Hostel in Fostoras. He came to Basotho Hostel and Sfiso called him to the bedroom. I must mention, my lord, that, and I will stick to my heads of arguments, which I've already dealt with before this court. My lord, holistically, from the statement of Ndanzi, accused number 2, there is no passage in his both statements to the effect that on the 26th of June, he had met Constable Zungu at Basotho Hostel. The statement further goes on to say, while they were at the bedroom, Sfiso, that is Sfiso's room, Carlos Tosen Mapisa accused 4 arrived. Carlos and Tosen Mapisa then called Kelly. They told her that they were all right. We all then left in a Polo Vivo. It was accused 1, Carlos, Tosen Mapisa, Sfiso, and Mozi. From this, my lord, there is no evidence that at some point accused number 4 was in contact. There will be evidence in Luede to the effect that at some point Mr. Mapisa, my client, was in contact with the so-called mastermind, Miss Kelly Kuman. We then all got out of the vehicle. Sfiso was the driver. Mozi was the lookout. Mapisa was to stand by the window. Carlos and accused 1 was supposed to get to the house. In this regard, I submit, my lord, that there is no evidence, independent evidence, from this confession statement to suggest that my client, accused number 4, at some point went inside the house after the 2 robbers had left the scene. Even the state witnesses, Ms. Zithulele Nxumalo, Tumelo Madlala, and Mthokozi Zithwala did not make any reference to an individual who came into the house after the 2 robbers had left. The statement further goes on. He ran out of the house. As he ran out, Tosen Mapisa came in. He ran and got in the vehicle. They remained in the house. Obviously, the statement goes on further to say that they followed each other to a certain motor vehicle which had been parked at a nearby. In this regard, my lord, one finds no corroboration or evidence alluende from the statement of accused number 2, that is exhibit JJ. It has been said, my lord, that confessions are not admissible against another. Section 219 of the Act provides that no confession may be made by any person shall be admissible as evidence against another person. A confession of one accused may not even be used indirectly against a co-accused. What is meant appears from the judgment of State versus Batman. It's a 1960 volume 3 SA 535. It's an appellate decision in which the 3 accused were convicted of murder. One of them made a confession implicating the other 2. All that connected the confessor to the murder was his confession, and all that lined the other 2 was the fact that the 3 were in each other's company at about the time of the offense. Although the direct implications of the other 2 in the confession was therefore correctly left out of the cost considerations, Nana JA found on appeal that they were nevertheless indirectly and wrongly connected to the murder. There are so many cases, my lord, that one can quote in this subject. I've dealt with them in my heads of arguments in an application in terms of section 174. One has in mind R versus Kosi and Zulu, 1950, volume 1, Prentice All, age 91, capital letter A in bracket, State versus Serobe, 1968, volume 4, SA 420A at 425G, State versus Makeva, and another 2003, volume 2, SACR 128 SCA at 133, paragraph 14. There's also international law in this subject. I've dealt with this, the decision by Lord Felsham of St. Marisbon, Asbury Law of Evidence, 4th edition, 1990, volume 2, 11, at paragraph 1131, which deals with confessions, that confessions are not admissible against the other.
So, were these confessions real? Or products of fear, pressure, maybe fabrication? Advocate Nxumalo has laid the groundwork. The cracks are showing. And this trial is far from over. Subscribe for more courtroom breakdowns. This is getting explosive. Don't forget to like, share, and drop a comment. Your voice matters, and I read each and every one. Thanks for watching. I'm Skybridge, and I'll catch you on my next upload. Goodbye.